Hello, dear friends. In the 11th lecture on the Erasmus Ecclesiastical law, I was speaking, and now I'm speaking now about the principle of prohibition of multiple religious organizations having the same faith base as a principle of identification of national identity with majority ethnic Orthodox identity. Belarus and Moldova by practice, Bulgaria and Fyrom by the specific laws, and Georgia by its constitutional agreement with Georgian Orthodox Church, each of them for their regions, impose the principle of prohibition of registering multiple religious organizations with the same faith base. Belarus and Moldova support the Belarusian Orthodox Church and the Moldovan Orthodox Metropolitan Church respectively, because these churches are subordinated to the Russian Patriarchate and the governments of these countries have close interstate relations with the Russian Federation. The Russian Federation secures its leadership role over Belarus, Moldova, and to some extent Ukraine, even through the Orthodox churches of these countries subordinated to the Russian Patriarchate. Now, in the present situation in Ukraine, the Russian Federation and the Moscow Patriarchate are very careful on this topic. It must be mentioned that Belarus and Western Ukraine have been historically areas of interaction, as well as of competition and conflict between the Orthodox Russian Church and the Roman Catholic Church. The same has happened with Transylvania and Romania between the Romanian Orthodox Church and the Roman Catholic Church. The Greek Catholic Church once had members approximately the 3/4 of the Belarus population from 1596 until 1839, when officially abrogated by the Tsar regime, but suffered from serious persecutions under the Tsar and Soviet rule. After the Belarus independence was restored, efforts of revival of the Greek Catholic Church had only limited success due to the determined opposition of the Belarusian Orthodox Church subordinated to the Russian Patriarchate. The Greek Catholic Church of Ukraine, led by Cardinal Huzar, constitutes the second larger group of believers after the Christian Orthodox churches. It was established by the Council of Brest in 1596 for the unification of Orthodox and Roman Catholic believers. It was outlawed by the Soviet Union in 1946. It was then by force subjugated to the Orthodox Russian Patriarchate. And finally, it was legalized in 1989. It currently has 18 provinces, 3,386 parishes, and 2,103 clergymen, before being outlawed in 1946 and subjugated by force to the Orthodox Russian Patriarchate. Their members estimated approximately 4 million, were the majority of believers in the western part of the country. For this reason, the border of the Orthodox cultural area was then delineated between the Eastern Orthodox part and the Western Greek Catholic part of Ukraine. Today, the majority of the believers in the western part of the country belongs to the Ukrainian Orthodox Church of the Kiev Patriarchate and the Ukrainian Autocephalous Orthodox Church, while, as the current situation stands, the believers of Ukraine Greek Catholic Church are an important minority. The Greek Catholic Church in Romania constituted part of the Romanian Orthodox Church until 1697, when it accepted the principles the Roman Catholic Church demanding from it to be unified with the Orthodox Church. It was the second larger denomination, approximately 1,500,000 of believers out of a population of 15 million. In 1948, when the communist regime outlawed it and ordered its forced fusion with the Romanian Church, transferring one part of the churches and other ecclesiastical properties of the former to the latter, while the state kept the other part of the properties. The state has not yet returned the larger part of those properties to the Greek Catholic Church. Moldova does not support the Bessarabian Orthodox Metropolitan Church because the church is subordinated to the Orthodox Romanian Patriarchate. The Bulgarian government strongly tend to intervene in the internal affairs of two larger denominations of the country, namely the Bulgarian Orthodox Church and the Muslim community, notwithstanding their right to autonomy guaranteed by the specific Bulgarian law. FYROM closely links its national identity with the identity of so-called Macedonian Orthodox Church for reasons of national security. Georgia supports the Georgian Orthodox Church, the church of the majority of the country, and not the Orthodox Church of Georgia, that is, a distinct church disagreeing with the Georgian Orthodox Church and not having recognized the authority of the Georgian Patriarch since 1997 for purely doctrinal reasons. This schism of ultra-Orthodox forced the Georgian Patriarchate to leave the World Council of Churches in 1997. This principle violates the religious freedom of dissenters within a religious community, and for this reason opposes the case law of the European Court of Human Rights. According to this case law, state measures favoring a particular leader or group in a divided religious community or seeking to force the community or part of it against its will to be put under one single leadership constitute infringement of the freedom of religion. Belarus does not register Orthodox churches other than the Belarus Orthodox Church subordinated to the Russian Patriarchate. The other four Orthodox denominations suffer from strict limitations and in practice are banned given that they are unable to be registered and exercise their collective religious freedom without the consent of Belarus Orthodox Church subordinated to the Russian Patriarchate. Those Orthodox denominations are the Belarusian Autonomous Orthodox Church, the Catacomb Orthodox Church, the True Orthodox Church, and the Russian Orthodox Church abroad. Moldova refused to register the Bessarabian Orthodox Metropolitan Church for 10 years and keeps refusing to do so with regard to the True Orthodox Church of Moldova, but True Orthodox Church of Moldova gained a judgment against Moldova in the European Court of Human Rights. The Bessarabian Metropolitan Church was established in 1992 when a number of clergymen left the Orthodox Church of Moldova. It is recognized by all the Orthodox Patriarchate and autocephalous churches, with the exception of the Russian Patriarchate. And it pretends over the Metropolitan Church of Moldova to the legal and canonical succession of the Romanian Orthodox Church before the Second World War in the today's territory of Moldova. It must be noted that an application of it is pending before the European Court of Human Rights against Moldova. For the reason that the Supreme Court recognized as legal successor to the Romanian Orthodox Church, the Metropolitan Church of Moldova, and not the Bessarabian Metropolitan Church, for purposes of all property ownership. The Metropolitan Church of Bessarabia was recognized by the State Agency on Denominational Affairs in 2002 after years of refusal by the state to do so. And after a judgment of the European Court of Human Rights in Metropolitan Church of Bessarabia versus Moldova in 2001, while the Metropolitan Church of Moldova had been recognized in 1993. The European Court held that Moldova's refusal to recognize the applicant Metropolitan Church of Bessarabia infringed Article 9 of the European Convention on the ground that it was disproportional to the legal aim sought, that is, the protection of public order and public security, given that by virtue of the 1992 Act, only the governmentally recognized denominations might be exercised in Moldova, while the applicant church, due to lack of recognition, could neither be organized nor function. The principle of prohibition of registering multiple religious organizations with the same faith basis has been applied in Bulgaria in the case of the Bulgarian Orthodox Church schism and the Muslim leadership dispute. The schism of the Bulgarian Orthodox Church came to an end after the decision of the Assembly of the Orthodox Patriarchs and Primates met in Sofia in 1998. The Synod decided that Patriarch Maxim and his Holy Synod, and not the alternative Synod of some Bulgarian bishops that opposed Patriarch Maxim's leadership, were canonical and legal. On the Muslim leadership dispute, the European Court of Human Rights delivered two judgments. The first on October 26, 2000, in Hassan and Chaus versus Bulgaria, and the second on December the 16th, 2004, in Supreme Holy Council of the Muslim Community under Gentsev leadership versus Bulgaria. In both cases, the European Court held that the governments of the Socialist Party and the Party of Union of Democratic Forces respectively infringed the Muslim community's right to organizational autonomy. In applying the principle of prohibition of registering multiple religious organizations with the same faith basis, the State Committee for the Relations with the Religious Communities and Groups competent to register religious groups in Fyrom rejected in 2004 the application of the Orthodox Archbishopric of Ahrid, led by the defrocked bishop of so-called Macedonian Orthodox Church, Jovan Joran Vranskovsky, to be registered as a religious group. This religious group was not accepting the self-declared autocephaly of the so-called Macedonian Orthodox Church, as the autocephalous Orthodox churches do so in general, is viewed as schismatic from the so-called Macedonian Orthodox Church. However, the Orthodox Patriarchate of Serbia has recognized it since May the 26th, 2005, as the single canonical Orthodox Church in Fyrom. This decision of the Orthodox Patriarchate of Serbia was, from a political point of view, considered as offense to the national identity of the country. Fyrom applied the following restrictions included in its specific law, contrary to international standards, on the Orthodox Archbishopric of Ahrid that disagrees with the stately supported so-called Macedonian Orthodox Church. First, the religious community and group, except for the other legal conditions, needs to take the positive opinion of the State Committee for the relations with the religious communities and groups to erect or acquire facilities to observe religious services and carry out religious activities. B. Permission from the competent authority in charge of internal affairs. After a prior opinion of the competent authority for the religious affairs, is necessary to observe religious services and carry out religious activities outside the establishment of religious communities and groups. And C. Collecting voluntary contributions to religious communities and groups for religious and humanitarian aims is prohibited outside the establishments where religious services are observed and religious activities are carried out. The constitutional agreement of Georgia with the Georgian Orthodox Church stipulates that the state, in agreement with the Georgian Orthodox Church, grants permissions for the use of official emblems and terminology of the Church. Georgia constitutional agreement with Georgian Orthodox Church This provision discriminates against dissenters, namely the Orthodox Church of Georgia, that is a dissenting movement within the majority Orthodox Church, for it is inconceivable for the Georgian Orthodox Church to agree with granting state permission for the use of official emblems and terminology of the Orthodox Church by the Orthodox Church of Georgia. And now another topic, direct or indirect prohibition of the freedom of disseminating religion of denomination other than the stately supported Orthodox churches or Orthodox groups disagreeing with those Orthodox churches in the countries of Orthodox cultural area. Direct prohibition of freedom of disseminating religion. Armenia, Greece, and Moldova. Armenia and Greece prohibit proselytization. Armenia permits only the Armenian Apostolic Church to exercise proselytism over its territory, except in this regard only the activities of recognized and registered religious communities allowed by its specific law. In Moldova, what is prohibited is excessive proselytism, namely any attempt to pressure by violence or misuse of power the religious convictions of someone. In Kokkinakis versus Greece, the European Court of Human Rights held that the Greek law on proselytization was consistent with Article 9 of the European Convention, to the extent that it did not violate the freedom of disseminating religion. It also accepted, but wrongly, that the law concerned did not infringe the fundamental principle of precise description of the punishable acts, nullum crimen, nulla pena sine lege certa, because it did not take into account the the whole body of reported Greek case law. Indirect prohibition of freedom of disseminating religion. Indirect prohibition of freedom of disseminating religion is attained through absolutely prohibiting fully freedom of exercising religion by non-registered denominations, Armenia, Belarus, Moldova, or imposing restrictions contrary to international standards on registering and carrying out religious activities or enjoying religious rights, Belarus, Romania, and Russian Federation, imposing by statute or judgment re-registration on already registered religious organizations, Belarus, Russian Federation, Greece, completely prohibiting the activities of registered religious organizations, Russia, non-recognizing the right to denominational autonomy, Greece, imposing by statute restrictions contrary to international standards on exercise freedom of worship, Greece, creating a tension in the relations with another church, Federation of Russia. Indirect prohibition of freedom to disseminate religion through absolute prohibition of exercising religion by non-registered denominations. The specific Armenia and Belarus laws fully prohibit non-registered religious organizations from collectively exercising religion. In Belarus, only in-house minor gatherings are the exception to the prohibition to the extent that they have no massive and systematic character. The same prohibition is applied by Moldova that makes the permission of organization and operation of denominations dependent on their recognition and registration by the state. Indirect prohibition of freedom to disseminate religion through restrictions contrary to international standards on registering and subsequently carrying out religious activities or enjoying religious rights contrary to international standards. Belarus hinders by restrictions contrary to international standards the freedom of religious organizations other than those of the Belarus Orthodox Church subordinated to the Russian Patriarchate to disseminate religion. It imposes restrictions the Belarus law on. First, setting up religious associations for which at least 10 local religious communities of one denomination as founders are necessary, of which at least one community has to have carried out activities on the state territory, that is, being a national one, for at least 20 years. B. Setting up assisting religious organizations, monasteries, religious fraternities of men and women, the religious missions by local religious communities. C. Carrying out religious activities by local religious communities and their associations only in the areas where they are registered. D. Importing and distributing religious literature. E. Considering the use of real estate properties of religious organizations by other religious organizations. F. Performing religious activities by foreign clergy invited by religious organizations. Despite the fact that it does not provide for a precise procedure for the recognition of denominations, and in spite of its practice to recognize traditional religions of the society, Romania gave various forms of state support only to recognized denominations in the past, favoring the expansion of those denominations and disfavoring non-traditional denominations. The Russian Federation specific law. First, introduces two forms of religious associations, religious organizations and religious groups. It gives minimal rights to religious groups, while at the same time it puts the obligation for them to exist for at least 15 years in a certain territorial area. It also obliges religious organizations that do not hold such a certificate to re-register for 15 years, and of course, during this period, it gives them fewer rights. B. Under the establishment of local religious organizations by natural persons of the same denomination, by laying down the condition of receiving from the local administration a certificate proving their existence in a certain territorial area for 15 years. However, this condition, according to the case law of the Constitutional Court, is active not for religious organization registered by virtue of the 1990 law, but for those applying to be registered for first time. C. Under the activity of small denominations that do not yet have centralized religious organizations, by providing that in order for their local religious organizations to exercise rights given by the federal law, their members have to set up and register such organizations in every territorial entity under the sovereignty of the Russian Federation, in which their denomination is interested in carrying out activity. D. Imposes on religious organizations already registered under the 1990 law to be re-registered, with the effect that some local registration authorities do not re-register certain already registered organizations of non-traditional denominations that had not ceased to be active, while other such agencies did not so. Indirect prohibition of freedom to disseminate religion through statutory Belarus Federation of Russia or judicial Greece obligation of already registered religious organization to be registered. After the specific Belarus law imposed the obligation for registration, the four Orthodox churches, other than the Belarusian Orthodox Church, subordinated to the Russian Patriarchate, were not registered. And some Protestant and Eastern denominations were not registered. After the specific Russian Federation law imposed the obligation of registration, some non-traditional denominations such as Mormons, Salvation Army, Jehovah's Witnesses, and Scientology have been faced with registration problems. For the Ministry of Justice, Moscow region did not register the Moscow branch of Salvation Army, contrary to the ruling of the Constitutional Court that ordered its registration. This religious group submitted an application to the European Court of Human Rights that held it admissible. The European Court held also admissible to similar application of the Moscow and St. Petersburg branches of the Scientology Church that had not been registered by the local registration authorities. The Cassation Court in Greece imposed the registration of the Canea Catholic Church in Crete as association of the Civil Code. The European Court ruled that this judgment was not in conformity with Article 9, in combination with Article 14 of the European Convention of Human Rights. The Greek government resolved this question through the recent law number 4301 of 2014, which contains a list of almost 240 religious organizations of the Catholic Church in Greece, to which this law attributes automatically legal personality under this law. And now we have to finish this 11th lecture. Thank you very much for your attention.